In the digital age, law has entered a new frontier, one defined by data, networks, and global communication. Cyber law governs everything that happens online: transactions, information sharing, privacy, and digital crime. Meanwhile, digital rights protect the freedoms of individuals in virtual spaces: freedom of expression, access to information, control over personal data. In this lesson, we will explore 20 essential legal English terms that define this rapidly evolving field, from data breaches to encryption, and from cybercrime to digital evidence. These words are used by governments, corporations, and lawyers worldwide. By mastering them, you will understand how law adapts to protect human rights and regulate technology in a connected world. If you want to discuss data privacy, cybercrime, or technology law in English with confidence, join our Legal English community. We host live sessions where students analyze cases every day involving data protection, hacking, and digital contracts. You'll learn not only vocabulary, legal terminology, but also how to use it in practice. Able to explain encryption or reviewing privacy laws. Join today and connect with the global network of legal professionals shaping the future of law by improving their legal English. Cyber law is the legal foundation of the digital world, the rules that govern how technology is used, managed, and protected. For example, cyber law addresses issues like online fraud, privacy, and intellectual property. It covers almost every aspect of modern life, from e commerce and data storage to criminal investigations involving computers. As society moved online, traditional laws became insufficient. Old definitions of theft, contract, and evidence needed digital adaptation. Cyber law now regulates everything from electronic transactions to network security and data ownership. It's international by nature because the internet has no borders. A single email can cross 10 jurisdictions in seconds. For modern lawyers, understanding cyber law is not optional. It's essential to practicing in any field touched by technology, which today means almost all of them. Digital rights are the human rights of the online world. Our example states, digital rights include freedom of expression, privacy, and access to information online. As life increasingly takes place in digital spaces, from social media to online banking, fundamental rights must extend there too. Freedom of expression means being able to communicate and access information freely online. The right to privacy ensures users control how their data is collected and used. Access to the internet itself is now recognized in some countries as a basic human right. Lawyers working in digital rights fight to keep technology ethical, inclusive, and fair. When governments censor content, companies misuse data, or algorithms discriminate, digital rights become the line between innovation and abuse, the legal shield protecting individuals in a connected society. Data protection ensures that personal information is handled responsibly and lawfully. Our example states, companies must comply with data protection laws like the GDPR. Every time we use social media, shop online, or fill out a form, we share data that reveals who we are. Data protection laws define how organizations can collect, store, and share that information, and what rights individuals have over it. Europe's GDPR, for instance, introduced strict consent requirements and severe penalties for misuse. Data protection isn't just a technical issue, it's a moral and legal duty that balances innovation with human dignity. For lawyers, understanding these obligations is crucial. Whether drafting privacy policies, managing cross border data transfers, or advising clients on compliance, with global regulations. Personal data is the currency of the information age. For example, names, ID numbers, and IP addresses are forms of personal data. It includes anything that can identify a person, directly or indirectly, from a simple email address to a detailed profile of behavior online. In law, personal data must be protected from unauthorized access, alteration, or disclosure. Misuse of personal data can lead to discrimination, identity theft, or privacy invasion. Lawyers working in cyber law must know how to classify, safeguard, and process such data in line with legal frameworks like GDPR or local data laws. Understanding what counts as personal data is the first step in every digital compliance strategy. It defines the limits of lawful information use in the modern world. A privacy policy is the public face of data protection, a company's promise to its users about how their information is treated. For example, the company updated its privacy policy to comply with new regulations. Privacy policies outline what data is collected, for what purpose, who has access to it, and for how long it is stored. They also describe users' rights to access, correct, or delete their information. Under laws like the GDPR, having a transparent privacy policy isn't optional, it's mandatory. For lawyers drafting or reviewing these policies, it requires precision and clarity, balancing business operations with legal obligations. A strong privacy policy builds trust between organizations and the public, proving that transparency is the cornerstone of modern digital ethics. Consent is the cornerstone of lawful data processing in the digital age. For example, users must give explicit consent before their information is processed. Consent must be informed, specific, and freely given, not hidden in long, unreadable terms. It gives individuals control over what happens to their personal data, empowering them to say yes or no to data collection. Under modern data protection frameworks, like the GDPR, silent or pre-ticked boxes no longer count as consent. Organizations must clearly explain why they need the data and how it will be used. For lawyers, consent is both a shield and a test. A shield that protects users' rights, and a test of compliance that can determine whether a company acts legally or faces major penalties. In short, consent turns data collection from intrusion into permission. A data breach is the nightmare of the digital world when private information escapes control. For example, the company reported a data breach affecting thousands of customers. Breaches can occur through hacking, accidental disclosure, or internal negligence. They compromise sensitive data, such as financial records, passwords, or medical histories, often causing reputational and legal damage. Under laws like the GDPR, organizations must report breaches quickly and notify affected individuals. Failing to do so can lead to heavy fines and loss of public trust. Lawyers play a crucial role after a breach, coordinating response teams, advising on disclosure duties, and managing legal liability. A data breach reminds us that in a connected world, cybersecurity is not just a technical issue, it's a core part of legal responsibility and corporate ethics. Cybercrime is the dark side of connectivity, crimes committed through computers, phones, or digital systems. For example, cybercrime includes hacking, online fraud, and identity theft. Unlike traditional crimes, cybercrimes are borderless and anonymous, often involving multiple jurisdictions. They can target individuals, corporations, or entire governments. Examples include stealing credit card data, spreading ransomware, or manipulating digital evidence. Governments around the world have passed new laws to address this evolving threat, giving law enforcement greater tools to investigate and prosecute digital offenses. For lawyers, understanding cybercrime means navigating a complex mix of criminal law, data protection, and international cooperation. The rise of cybercrime challenges one basic assumption of justice that the criminal and the victim share the same physical space. In the digital age, they can be continents apart, connected only by code and consequence. Hacking is one of the most recognized forms of cybercrime, entering systems without permission to steal, modify, or disrupt data. For example, the hacker gained access to confidential government servers. Not all hacking is malicious. Ethical hackers, often called penetration testers, help organizations find vulnerabilities before criminals do. But when hacking crosses legal boundaries, it becomes a serious offense, punishable under national and international law. Hackers may expose sensitive data, plant malware, or disable essential infrastructure. For lawyers, the challenge is defining intent and proving authorization. Did the person act to help security or to commit theft? The distinction can mean the difference between a lawful test and a felony. Hacking law shows how digital behavior requires new moral and legal definitions for an interconnected age. Malware, short for malicious software, is the weapon of modern cybercrime. For example, the malware infected thousands of computers, encrypting their files for ransom. It includes viruses, worms, trojans, and ransomware, programs created to steal data, damage systems, or demand payment. One famous example, the WannaCry attack, crippled hospitals and companies worldwide. For lawyers, malware raises complex questions of liability, attribution, and damage recovery. Who is responsible when malicious code crosses borders? How do you prosecute an anonymous attacker behind layers of encryption? Cyber law provides remedies, but prevention remains the best defense. Understanding malware is no longer just for IT experts. It's essential legal literacy in a world where digital security equals legal compliance. Phishing is digital deception, the art of tricking people into giving away secrets. For example, the phishing email tricked users into revealing their login credentials. Phishing often uses fake websites, emails, or messages that appear legitimate, from banks, employers, or government agencies. It exploits human trust rather than technical flaws, making it one of the most common and effective cyber crimes. Victims may reveal passwords, credit card numbers, or personal data without realizing it. Laws against phishing overlap with fraud and identity theft. Laws against phishing overlap with fraud and identity theft statutes. For lawyers, the challenge lies in proving intent and tracing anonymous digital footprints. Phishing reminds us that cyber law is as much about psychology as technology, protecting not only systems, but the people who use them. Encryption is the digital lock that safeguards privacy and trust online. For example, encryption protects confidential communications from interception. It transforms readable information into coded data that can only be accessed with a key. Governments, banks, and everyday users rely on encryption to secure emails, financial transactions, and stored files. Without it, modern life, from online shopping to medical records, would be dangerously exposed. However, encryption also raises legal debates. Should authorities have access to encrypted data during criminal investigations? Balancing privacy with national security remains one of the most complex questions in cyber law. For lawyers, understanding encryption means understanding the boundary between safety and surveillance, where digital freedom meets state responsibility. A digital signature is the electronic version of a handwritten signature, proof that a person approved a document. For example, the contract was signed using a verified digital signature. It uses cryptographic technology to confirm identity and ensure that the document hasn't been altered. Digital signatures give legal validity to online transactions, making e commerce and remote business possible. They are recognized by international frameworks such as the For lawyers, digital signatures raise key questions. What standards define authenticity? How can signatures be verified across borders? Understanding these mechanisms is vital for drafting contracts, notarizing documents, and enforcing agreements in the global digital economy. An electronic contract, or e contract, is a traditional legal agreement executed entirely online. Our example says the parties concluded the sale through an electronic contract. E contracts are formed through emails, clicks, or online platforms where acceptance is recorded digitally. They are legally binding as long as there is mutual consent, clear terms, and proof of agreement. Electronic contracts power e commerce, cloud services, and countless daily transactions. For lawyers, the main challenge lies in proving authenticity, identifying who clicked, when, and under what conditions. Electronic contracts demonstrate how law adapts to modern communication, where signatures are digital, delivery is instant, and jurisdiction can span continents. E commerce is the digital marketplace where law, technology, and business meet. Our example states e commerce platforms must protect consumer rights and secure online payments. It includes everything from online retail to streaming services and digital marketplaces. E commerce has revolutionized how contracts are made, goods are delivered, and disputes are resolved. But with convenience comes complexity. Issues of jurisdiction, data protection, and fraud now cross borders daily. Governments worldwide have enacted laws to regulate online transactions, requiring transparency, refund rights, and privacy safeguards. For lawyers, mastering e commerce law means understanding consumer protection, intellectual property, and cybersecurity all at once. E commerce is not just a business tool, it's a living example of how law evolves with technology to preserve trust in global trade. In the digital age, intellectual property, or IP, is both priceless and vulnerable. Our example says copyright law protects intellectual property like music, code, and online publications. Every image, song, or line of code uploaded online is an original creation, and therefore an asset protected by law. But the internet has made copying effortless and enforcement complicated. Copyrights, trademarks, and patents now extend into virtual spaces, from social media posts to mobile apps and artificial intelligence models. For lawyers, digital IP raises new challenges, proving authorship, tracking infringement across jurisdictions, and balancing innovation with protection. Without IP law, creators would lose incentive to produce. Without reasonable access, society would lose progress. The law must constantly adapt to ensure that creativity and commerce thrive side by side in the digital marketplace. Cybersecurity is the defense system of the digital world, the practice of protecting data and infrastructure from attack. Our example states strong cybersecurity measures prevent unauthorized access and data loss. It includes firewalls, encryption, multi factor authentication, and monitoring systems that guard against hackers and malware. For organizations, cybersecurity is no longer a technical issue, but a legal one. Data protection laws often require companies to maintain adequate security or face liability for negligence. Lawyers working in this area help draft cybersecurity policies, respond to incidents, and ensure compliance with national and international standards. Cybersecurity defines the modern relationship between technology and law. It is where prevention, responsibility, and accountability intersect to keep the digital ecosystem secure. Digital evidence is the new paper trail of the modern world. Our example states emails and metadata were admitted as digital evidence in the trial. It includes everything from text messages and GPS data to cloud files and server logs. Digital evidence must be authentic, reliable, and properly preserved to be admissible in court. If data is altered, deleted, or collected illegally, it can be excluded entirely. For lawyers, understanding digital evidence means mastering both procedure and technology, how to obtain, verify, and present it without breaching privacy laws. In an era where truth often lives inside a device, the ability to handle digital evidence has become an essential skill for every litigator. In cyber law, jurisdiction becomes a puzzle within global pieces. Our example states cross border data disputes often raise complex questions of jurisdiction. When an online transaction occurs between parties in different countries, which court has the right to decide the case? Traditional jurisdiction depends on geography, but the internet defies borders. A social media post in one nation can cause harm in another. A cyber attack can be launched from anywhere. Courts now use new principles, such as targeting and significant connection, to determine authority. For lawyers, defining jurisdiction means balancing national sovereignty with the reality of a borderless web. Cyber law is reshaping how nations share responsibility for global justice in the digital era. Regulation is the tool that keeps digital freedom aligned with public responsibility. For example, data protection regulation sets strict requirements for tech companies. Governments use regulation to manage how data is collected, shared, and secured, balancing innovation with citizens' rights. Internet platforms, social networks, and artificial intelligence systems are all subject to growing regulatory oversight. For lawyers, understanding digital regulation means staying ahead of constant change. What's legal today may be restricted tomorrow as technology evolves faster than legislation. Effective regulation must be clear enough to protect users, but flexible enough to encourage progress. It's a delicate balance that defines modern cyber law. Now, let's look at a story that puts it all together. A startup specializing in e-commerce collects personal data under a clear privacy policy and user consent. After a data breach exposes customer information, regulators investigate under national cyber law and data protection rules. The company's servers were compromised through hacking and malware, part of an organized cybercrime network. Digital forensics recover digital evidence, proving unauthorized access from another jurisdiction. While authorities debate regulation and liability, the company upgrades its cybersecurity and implements stronger encryption. All clients sign new electronic contracts with verified digital signatures. Meanwhile, artists file intellectual property claims after their content was stolen and sold online, testing global enforcement of digital rights. In this story, every concept of cyber law connects, showing how technology, human behavior, and legal systems intertwine in the pursuit of digital justice. You have now learned 20 of the most important terms defining cyber law and digital rights, the language that governs privacy, data, and innovation. From encryption and e-commerce to cybercrime and regulation, these concepts form the backbone of global digital justice, but true fluency comes from practice. Inside our legal English community, You will apply these words to real-world scenarios. You will connect with professionals from around the world in live sessions as well as in our self-study course. You'll be able to master the English of modern law and technology. Join today and take the next step toward becoming fluent in the future of law.